Okay, so welcome everyone, and thank you so much for joining us today for this webinar, What's Next for Robodebts. My name is Carly Hanson. I'm the Sector Sustainability Coordinator at Community Legal Centres Queensland. Before we get started today, I'd like to acknowledge the traditional owners of the land on which we're holding today's session. In Brisbane, where I'm located, the traditional owners are the Turrbal and the Yagara people, and I wish to pay respect to their elders past, present and future, and acknowledge the very important role that Aboriginal and Torres Strait Islanders continue to play in our society. As today's webinar is being viewed by people throughout Queensland and across Australia, and because we've got presenters coming to us today from New South Wales and Victoria, I'd also like to pay my respects to the traditional owners of the land throughout the country and extend a very warm welcome to any First Australians who are joining in today. So I'm really pleased to welcome three great presenters and experts in this area to present today's session. So firstly, we will hear from Terry Carney from the University of Sydney and former AAT member. And then we'll hand over to Miles Brown and Charlie Brumby-Rendell, who are lawyers from Victoria Legal Aid and who were part of the federal court action in this area to do their presentation. So I'll let them all tell you a little bit more about themselves when I hand over in a moment, but just a bit of housekeeping firstly. So today's webinar is being recorded and we'll have the webinar available to download later today or tomorrow for you. The PowerPoints and other materials have also been emailed out to everyone who registered as of about 10 o'clock this morning, and I know there were a few extra registrations, so if you haven't received that email, you can download those PowerPoints from the handout section of the GoToWebinar control panel. We'll have questions at the end of today's session, just to make it a little easier to run through. You can type those questions in though at any time, so just type them into the question box on the GoToWebinar control panel and I'll see all of those come through. And read them out to our presenters to respond to at the end of the session. Alternatively, if you've got a microphone and you'd like to ask your question verbally, you may do that. So if you just pop up your hand button when we get to the end of the session, I'll be able to unmute you and you can ask your question that way. So I will now hand over to Terry Carney, who will be presenting for us first. Thank you so much, Terry. Take it away.
Thank you very much, Carly. Great. I'd like to acknowledge the Wundiwundian people from the area where I'm presenting down near Nowra, Culburra Beach. I'm going to talk just to these slides, which in many respects are an introduction to some of the more practical questions towards the end of mine, and particularly with my two esteemed expert speakers who are going to follow me. So an amount of this will, I hope, already be part of the furniture known to people, but I'm just sort of reminding people of the background. Happy to elaborate in questions later if need be, but I'm going to try to do this in no more than 15 minutes, maybe even a little less, so that we've got plenty of time for other presenters and the questions that people might have. I've realised I've left the wrong title on the first slide, so ignore that. There was one of these a little while ago. Now, is this thing going to work? I think I want to. What's it doing to me? Yes, it does. Okay, so this is what I'm going to be talking to in these slides. Brief introduction, you've had that while I was dealing with the getting my fly-ins to fly. Firstly, I'm going to be reminding you why Robodebt was illegal, what happened in 2019 when the federal court required a capitulation by the Commonwealth, and basically then where that leads us to the future. So that's just the outline. Really new content, I suppose, to the extent that it's new, towards the end of my presentation, is already set out in the Social Security Rights Review, the reference to which is there at the bottom of the slide now. and it's been out for whatever it is, about 6 to 8 weeks or more, for anybody who wants to follow up. So the introduction, 19th of November, nearly a year ago, the morning after conceding that it couldn't even present arguments to try to defend Robodebt against the action that had been brought in the federal court. And during the week or so that it took to draft up the orders, the government took advantage of, well, pretending really, that it had a degree of a change of heart, which of course it hadn't. It had just lost by its inability to defend a motto. You all know that it was a revenue-raising measure, that it was all designed to balance budgets and raise huge sums of money over the full life of the program. And there are references, if you're wondering how much more by way of unlawful debts raised from vulnerable people the total sum might have come to. Well, that reference in the second dot point will tell you. The long and the short of it was that it was unlawful as well as being unethical and very poor governance. It was unlawful because Centrelink, not the supposed debtor, bears the onus of proving the existence and the size of any debt. It never was a legal foundation to rely upon an extrapolated average. Average, of course, for anybody who's new and doesn't know, I suppose, an average that wasn't apples and apples anyway. It was a very different concept of what was being reported to the Australian Tax Office by employers of earnings over vastly longer periods than the fortnight by fortnight recalculation of a person's entitlement to their rate of a working age payment that must be the basis of any proofs of the debt. So in short, what Centrelink relied on in the Robodebt averaging was not a proof of the thing at all. I mean, it just did not compute at all with the obligation in terms of the factual matter, i.e. the fortnight by fortnight earnings that a person may or may not have had. And it was unethical for the reason that's pretty obvious, that the debts were either non-existent or they were greatly inflated. So moving to the scale of the Robodebt issue, it originally was of the order of 3.7 billion. This was the number of Robodebts back in earlier iterations of the scheme, some of which, a very small proportion before they lost a federal court action, had been the subject of very minor adjustments. The average debt was around $2,000, but of course it wasn't uncommon to have them much greater than that. Sources, again, for anybody who didn't know that and needed to follow it up. The key was that large numbers of the most vulnerable were frightened into paying up these debts. So why was it unlawful? I've already said that, because Centrelink, under the legislation itself, those sections that are quoted there, was always, well, the two legs to this. It's a debt if and only if, and that's the language of the Act, a section of the legislation makes it a debt. And then secondly, there's the question of the obligation to, on Centrelink, to prove the elements of showing that whatever section of the Act is being relied upon to raise the debt is a relevant, pertinent, and a sufficient proof. And the information that Centrelink was relying on wasn't pertinent or relevant, and they certainly didn't have enough of it. You know that we're only talking about working age payments. We're not talking about the pensions, where there's a different basis for establishing whether what a person's rate of a pension, like a disability support pension or an age pension, might be. The reason that we're talking about the working age payments and the fortnight by fortnight calculation is because that's what the benefit rate calculator for the relevant payment, in this case it's job seeker as it now is, used to be called New Start allowance or youth allowance. They're the two principal ones that were an issue, and the sufficiency of proof came from a full federal court ruling a very long time ago in 1984 that said there's a practical onus on Centrelink to establish things, and then the Brigginshaw principle that says when it's something that's morally contentious, that leaves a potential stain on the character of an individual, then there's a higher onus than there would be if it didn't have that moral stain character. All of that was vindicated when the federal court action, when the federal government folded its tent before it got to the camping ground kind of thing. Then there was the November capitulation, and I realised that I've got the wrong slides here that are coming up. I've inadvertently loaded the wrong slides. Can you, Carly, can you perhaps share the screen of the correct slides, and I'll just quickly take you through I thought there was something a bit odd about what I was discussing at greater length than I wanted to.
Sure, Terry. I'll just bring them up, everyone. If you can just bear with me a moment.
Yeah, apologies for that. I should have checked by running them when I was looking at them. I don't know why it came. It's not come up.
Okay.
No.
Okay, everyone, hopefully you can see those. So I think Terry's gone through the outline, so I'll just click through. Terry, let me know when you'd like me to stop.
Yep, yeah, keep clicking quickly so I don't take up too much time. I gave a webinar on this with those previous slides a long time ago, and I recycled in Sketchy a couple of the early ones, and I hadn't noticed that you've got the wrong ones.
All right, I think
so
we're
now up to the ones that matter. Yeah. So the outstanding issues in the class action that is due to come back to court at the earliest on the 20th of November are establishing two things: whether interest should be paid on the debts that were found to be unlawful. It's around $750 million of debts at the very minimum that the Commonwealth itself accepted it had to repay after folding its tent before it got to the camping ground of the court action. Interest on the monies is straightforward. They are obliged to pay interest on the monies that had been collected. I'm giving you a legal opinion on this. The liability for damage, for negligence, I'll say no more than that it's going to be a harder road for the class action to travel down in establishing that. And the reason for that is that finding government authorities to owe a duty of care and therefore then to have breached that duty of care and then to calculate whatever the damage of the harms that flow from it There's a quite big case law, number of High Court cases that one has to pick one's way through, and other commentary that just confirms what I'm saying, that it's harder to establish than it might be if you were suing in civil litigation. The government repayment scheme leaves open those four things. Whether it covers the 70,000 people who didn't respond to their Robodebt letters, and the answer is, in my opinion, as I've set out in that piece that I mentioned, is that it is indeed, it does indeed extend to that. That is also an issue in the class action, and so until the class action is determined or settled, one way or the other, we won't know a definitive answer to that. The second question was, well, what's the form of repayment if you're on income management? My answer to that is that you have to put a person back in the exact situation that they were in at the time that you raised the unlawful debt against them. So if they weren't on income management, then they are entitled to get their money in cash, so to speak, rather than by it being loaded onto any card that they might have subsequently been put on. And there were two other issues in relation to how Centrelink's administration and all the people who spent about 6 months with about half of the staff, 300 or so public servants, trying to give answers to these kinds of things. What is Centrelink going to do when they don't have adequate addresses or electronic banking records? And the answer, if they don't have your electronic banking records, is that they but do have and know your address, is that they must send you a check for the amount in question. And there are some other issues there around AAT reviews, which are really moot because the previous Federal Court, Amato, or the class action is going to, give the writing instructions legally as to what Centrelink has to do on that. And that's the correct one. So the one-touch future, now that's going to be touched on by, so just bring up all those slides, Carly. Thanks. Because that's, my colleagues are going to talk in greater length about that. It largely overcomes the kind of issue that Robodebt posed of this enormous lag between when people had originally reported, which, as people may know, was 6 or more years previous to the debt being raised in the vast majority of Robodebt cases. This makes it contemporaneous, and it's starting to compare an apple with an apple, because employers under the one-touch tax system, if they sign up to it, are indeed reporting what they say they paid in a payment, in a salary or income payment period. There's an issue around whether that maps exactly. Of course, it won't to the Social Security payment period, but it means that similar information is being compared almost immediately. To do that, the enormously exhaustively expansive definition of income, which used to cover things that were earned, things that were derived, and things that were received, basically had to shift towards the latter of those, that trinity, that trilogy, and that poses some conceptual and practical and other issues around the other ways in which income and the timing of its receipt used to be assessed. So that's why I've suggested that there may be some future Robodebt type conniptions, but they're ones that are on this occasion going to move from more from working age payment recipients towards the pensioners, the ones who weren't caught by Robodebt, at least before it was stopped. Okay, so we could move from that to the next one, which is the conclusion. That Robodebt tarnished the brand of artificial intelligence. I'm a member of the Centre of Excellence of the ARC that looks at the social impacts of artificial intelligence. And, you know, like any new technology, you know, from the typewriter onwards, there are pros and cons, and properly used, intelligently and creatively used, artificial intelligence can be more boon than bane. It can be of greater benefit to vulnerable, powerless people if it's used correctly. The problem has been, of course, that it was rolled out in a most incompetent fashion, unlawfully and poorly designed, with enormous harm, and that's you know, blotted the copybook of anybody's you know, likelihood of trusting it in the future. So despite you know, when we look back on Robodebt in 10 years' time, I think we'll say it was a great catastrophe, but ultimately the victims you know, got reasonable redress. The third one is that we shouldn't allow such an abomination, a catastrophe, to ever occur again as a consequence of A, it being rushed, and B, there being inadequate accountability oversights to it. Yeah, next one. So we need rule of law protections. I've written about that, and I think I've got those two references. If you click them up, there they are. One of them is a blog, the admin law blog from the 1st of September, and the other is from the Alternative Law Journal from middle of last year. Okay, and I think that concludes my time in a fraction over the 15 minutes due to my having the wrong slide up. There are some references that people will see attached to the slides. I can now hand over, I'm pleased to say, to Miles. Thank you.
Thanks, Miles. You should have your link on your screen if you want to click that and share your slides. Thank you.
Hi, everyone. I'll just make sure that you can see my slides. Carly, is that looking right? Because I've also got the webinar app up. So is that blocking it or?
No, you're perfect. Thank you so much, Miles.
Great. All right. So my name is Miles Brown. I'm the Managing Lawyer in the Economic and Social Rights Program. With my co-presenter, Charlie, we had carriage of the matters of Madeline Masterton and Deanna Amato. And this was also part of a campaign which Victoria Legal Aid run, obviously, with many other people in the community and activist organisations about Robodebt. And the kind of internal title that we used and that we used on all our external promotion was Rewinding Robodebt, which is why the slide's got that on it. You can see a picture of the two test case litigants here down the bottom. Charlie and I are in the middle. Madeline Masterton is with the stripes, and the floral is Deanna Amato. Incredibly, those two litigants were, the case involved the earnings that they incurred whilst working very close to each other in Brunswick Street in Melbourne at around the same time. So kind of the equivalent of them working at the Zoo and Rick's Bar in Brisbane, I guess. I also neglected to mention that I am on Wurundjeri land, and it's land that was never ceded, and I pay my respects to their elders past, present and emerging. So we were going to talk a bit more about single touch payroll. I think a lot of the thinking about Robodebt and what was wrong with the approach the government took in Robodebt has, as Terry indicated, been in many ways addressed by a fundamental change in the way that income is going to be taken into account for the purposes of determining whether a person is eligible for an amount of a payment in a particular fortnight. And as Terry explained, the primary focus is on the concept of when the person was paid, and not when they earned that money or derived the money. So I thought I might take some time just to kind of give some early thoughts about our analysis of how those particular provisions are going to operate, because they do interact with some concepts of averaging that I think the Robodebt experience is going to be relevant to. And there are scenarios that we've identified where similar type averaging might be in play for clients, and where there might be some options as a result of the fine detail of the legislation that we can pursue on behalf of clients. Firstly, I might just confirm that our clients are probably beginning to receive, and I haven't spoken to anyone who's had it, but pre-filling in their form. So I wouldn't be surprised if we're beginning to see from the 20th of September that the interaction that's anticipated under this legislation between the ATO and Centrelink is already occurring in people's MyGov, and there will be some questions, I think, that I will get to about how clients respond to that information if we are starting to see pre-filling. In addition, the actual implementation, which was originally supposed to come in the middle of this year, has been moved till the 7th of December 2020, so not far off really. And I should note there's a transitional fortnight, which I'm sure there will be some trickiness with navigating, but hopefully it'll be pretty straightforward for most recipients. I wanted to just get into the three kind of key concepts that are going to be in play for clients seeking advice about how they report their income. The first one is the employment period, and this is all defined in the legislation. It's not in the current legislation. I assume that it will just emerge there on the 7th of December and be applied from that date. The employment period is the particular period or periods over which a person, over which one or more payments are made into a person's account. So basically, the key kind of calculation here is about what is the employment period, and it's about looking at when a person has received the payments into their account. And from that flows the kind of whole process for determining how that income will be treated. The other key element is the assessment period and the instalment period. So the instalment period is what we understand usually is the kind of the period, the fortnight over which a person's entitlement is being assessed. So usually when a person puts in their, as we know, puts in their reporting in relation to their income for a particular fortnight, that's the instalment period. And the assessment period is the number of days between the kind of employment payments that, the number of days that the person earned the income for. So maybe I spent some time trying to get my head around this morning, and I'm just concerned I've got it slightly wrong, but I'll just quickly read my notes. Yeah, so the assessment period is the period overlaid over the instalment period, which is the employment period, which is the period between the pay that you've received the payment for. So they provide an example in the legislation, which was really helpful, which is that a person receives $756 for 21 days, being between the 9th of May and the 29th of May. They received that $756 on the 3rd of June. Their instalment period begins on the 1st of June. And so what happens is, because it's a 21 days worth of payment received on the 3rd of June, the way that it's supposed to work is that the person then, from the 1st of June, that first day of their instalment period, they then average out that $756 over 21 days from that 1st of June. So what we're really seeing is a real change. It's not that income, they're not trying to take it into account at the time you received it, they're just looking at the time you were paid, and they're applying it in a forward fashion from the beginning of the instalment period that you received it, and using a calculation to work out what period that should be, to work out how many fortnights it should cover. There's an added layer to it, which is where if in overlaying it, it goes over 3 weeks, so just say 2 instalment periods. For that second fortnight, the idea is that you then average it again over the whole fortnight. So in the example they give, that $756, you've got, and I trust their calculations, I haven't done them, it's $36 a day for the first fortnight, and then that halved for the remaining 7 days of the 21 days, so $18 a day for the second fortnight. So it's a very different, it's going to be quite a different way of assessing debts and assessing entitlement. And it's a relief, I guess, that so much of it is going to be automated. But when we're providing advice to clients about those processes, I think we're going to need to get our heads around how the Centrelink is going to be calculating all those inputs. And the key confusion that we've identified is likely to be the question of what is the employment period. So, and how is that going to be communicated to Centrelink? So often that's going to be obvious for a person working part-time in set employment, but for casual employees or people doing work that is contract work, where you might get one large payment for 2 months' work, it's going to be really important the information that the client gives, and that will obviously impact on the way in which any debt is calculated. And more importantly, it's not going to be a debt, it's going to be their prospective payments, because the way it works is once it gets paid and you notify them, then the impact is on your future payments, not your past payments. Obviously, if you notify them of an old payment, it will be applied back when you receive the old payment as a debt. But if you receive a payment, i.e. a back payment for income you earned, there's going to be real questions about how Centrelink treats that. So some of the questions that we have, and I think it's going to be a watch this space, is with that calculation of what is an employment period. Is it the pay cycle? Is it the actual number of days a person works? So if a person works 3 days in a fortnight, is the employment period 3 days? Or is it going to be the days worked bookending? So if a person works 3 days over a month, is it just the time between those 3 days, or is it the whole month? So there's going to be some real complexity to that, and because it's that particular determination about the employment period that then sets the period over which any income will be averaged. The second question, and so again, we just don't know the process of that is going to be for that. So are people going to have to confirm the employment period when they get the notification that their information has been uploaded into the system? Is there going to be some automated processes for doing that? The second kind of key area that we are interested in, and this is where the averaging comes in, is where you have payments that are identified as income that don't cover a particular period. And there's a particular provision, section 107(3)(b), which covers how that will be dealt with. And so one of the key concerns we had when looking at this legislation initially, and it remains a concern, is how Centrelink is going to go about determining what a particular, well, firstly, when has a person said that there's not a particular period, i.e. if a person just reports, or Centrelink determines by looking at someone's bank statements that a payment has been made at a particular day, is Centrelink going to, how is Centrelink going to determine that that payment, or the payment period that payment covers? And our understanding is Centrelink will need to make some type of determination in relation to that, either that it covers a payment period or that it doesn't, and therefore it will exercise the discretion to average that out over a period of up to 12 months. So it's that second tier of thinking, that discretion where there's no payment period identified, where Centrelink again still has this power to average. Now, one of the good things is that the legislation provides some protection, and that was as a result of changes made to the original legislation by the Senate. And so in determining how to treat that one-off payment of income that doesn't have a particular period, Centrelink needs to consider the nature of work, the nature of employment, the person's financial interests, any financial hardship that might be caused, and whether it relates to remunerative work they've undertaken previously. And so what you might have is you might have a person receiving a large back payment for income that they should have received in the previous period, or they might apply for payments and then get a large back and then get paid from an employer for work they'd done 3 months or 4 months prior. And there'll be a real question as to how that's treated, because Centrelink does have to average that out over a period, and you might find that you're making submissions that should be averaged out over just a fortnight, so that it only impacts on 1 fortnight's payment and not the remaining year or 6 months or 3 months of payments. So our reflection, I guess, is that there's going to be some real change in the way that we provide advice and assist clients and the way that debts are raised. And I think our knowledge of these provisions hopefully will develop as we get to see them in practice. But yeah, I think it's important to be aware of that process in relation to determinations of a particular period and some of the options that we might assist clients with in seeking a review of decisions in relation to that. I think the final thing to say about single touch payroll is that the Senate also included a review provision, and the review actually usefully will have to be conducted within, I think, 6 months, or I'll just find the section. Written report of the review within 6 months of the commencement of the review, and must be started as soon as practicable after the end of 12 months after the act commences. So and the key thing is that they must consult with income support recipients, persons who have expertise in social security law, being all of us, and persons who have expertise in any other area of public policy considered relevant. So I think the other thing to keep in mind is to ensure we collect case studies about how the law's working. I'll just go on to the next slide. I thought I'd quickly summarise the refunds. So as we heard, there's 721 million in total. There's 373,000 people are receiving refunds, but also another 50,000 debts have been set aside, and those were debts where no payments had been made towards them. And hopefully your clients will have received refunds. They should all be done by November 2020, as far as we understand. And I think the hurdle has been providing bank details. So obviously that's a key piece of advice for clients. And as I was looking at this, I noted that there's at least 7,000 people who have refunds above $7,000. Apparently there's some technical difficulty in refunding more than that. I thought I might quickly capture, or try to capture as well, that the $721 million, if you average that out over the whole period of Robodebt, it's about $500,000 a day that they're having to pay back for every day that Robodebt was operative. So it's a huge amount of money. I'll just go on to the next slide. Finally, I was just going to talk before handing to Charlie about some of our reflections about the 10% penalty fee, and I'm conscious of time, so I'll speed through this. But one of the other issues that we asked the court to consider in Amato was the imposition of penalty fees, which was routine as part of Robodebt, and we never really understood why it was being applied. The reasons for that is that, and as we articulated in the case, and you can see from the wording, it seemed like Centrelink was saying that they could apply a penalty fee. And just to go back a step, most of you I'm sure would be aware that when a debt is raised, that Centrelink does have the capacity to raise a 10% fee in the circumstances described there, where a person's refused or failed to provide information about their income, or knowingly or recklessly provided false or misleading information when required to under a provision of social security law. And we often have historically seen that raised with debts where there's a suggestion of fraud, and sometimes in a broad range of circumstances. But it was a real shift for Centrelink, and you can see it in their policies, to automatically apply 10% penalty fees to Robodebts. And as I was explaining, we never understood it because the Centrelink seemed to be relying on this refusal or failure to provide information, which was the refusal or failure to play ball when Centrelink asked for more information about a person's income about income in response to the ATO information. Our position that we put was that that requirement to provide information needs to be a requirement under social security law. And as we know, there's provisions that allow Centrelink to send a formal request for information in relation to a particular issue. The letters that were sent out were not those Section 68 formal requests. So our view was that it's not possible to apply that 10% penalty under that first limb of refusing or failing to provide information. The second limb of knowing or recklessly providing false or misleading information, we said engaged with this concept of brigand short. So we were saying you can't make a positive finding of recklessness or misleading information where you've not had a conversation with that client and been able to deduce the basis for, firstly, that information wasn't provided, but secondly, that it was done in a way that was knowing or reckless as to whether it was false or misleading. So the outcome in Amato was that the Commonwealth conceded that there was not sufficient material before the decision maker that allowed them to support the conclusion that these limbs were satisfied. And we would say as a result of that, that you would need to either have a failure to comply with the Section 68 notice or some other obligation under social security law, or a positive finding of knowing or reckless provision of false or misleading information based on a conversation with the client or some other compelling evidence that would meet a brigand short test in order to add that 10% penalty fee. So something to look out for in your practice, and then I'll hand over to Charlie to talk about the garnishee power.
Thanks, Miles. So I like the 10% penalty, I guess, practice. I'm sure many of you are aware that one of the more controversial things that was happening with Robodebt was Centrelink's wide use of their garnishee power, which mainly occurred in taking people's tax refunds, but also, as I'm sure you'd be aware, could involve them Centrelink garnishing the contents of people's savings account. And so what we raised in the context of the Amato case was, and the kind of bare facts for Deanna was that she was not aware of her debt until she didn't get her, was informed by her accountant that she wasn't getting her tax refund because Centrelink had taken it. And so what we were raising in the Amato decision, and I've extracted part of the provision there about what Centrelink has to be satisfied or established before it can use its garnishee power. And the first part is that they must, they have to first attempt to recover the debt, and then they have to establish that the person who owes the debt has failed to enter into a payment arrangement or has not kept up with one once they've entered into one. And what we saw with Robodebt was that Centrelink's view was that they meet that those requirements simply by sending someone a letter, even if they don't even know whether the person's opened the letter or received the letter, that they can meet those requirements because they've attempted to recover it by putting the letter that people need to start paying it. And then if a person doesn't do anything in response to that letter, well, then they've failed to engage into a reasonable payment arrangement. We argued that that this provision requires a lot more engagement from Centrelink than that. And there are some AAT decisions that say the same thing, that that you have to have, effectively, that some AAT decisions say that you have to have at least had a conversation with the person, and Centrelink has to say, we want you to pay 100, and the person has to say, no, I'm not going to, before you can meet this requirement. Now, this aspect didn't get considered in the Amato decision. Rather, it was just conceded that the garnishing of the tax return was unlawful because there was no debt to begin with. And so this hasn't been separately considered by the federal court, and it's unclear to us whether the practice will change. As we understand, with COVID, there's been a lot of changes in the use of the garnishee power with the general pausing of debt recovery is, and changing of those debt recovery methods. But it's definitely something for us to watch kind of going forward, what how they're going to use this power and whether they're going to, I guess, maintain the position that they have with Robodebt on that. Next slide, Miles. And just, I'll just kick off this before I hand back to Miles, but with another aspect that I'm sure people were familiar with that was, I guess, frustrating with Robodebt was people's inability to access the meaningful merits review. So obviously under social security law, people are entitled to seek internal review of a decision to raise a debt against them. But what we saw in Robodebt was that there were quite a few obstacles put in the way of this. And that had a flow-on effect because, of course, you can't apply to the AAT for review of a decision in absence of an internal review decision from Centrelink. And we saw that that flowed, through to the numbers. The statistics that we saw through the Senate inquiry were that something like only 1% of all Robodebts actually received an internal review decision. And then, of course, it's only a very small subset of that. I think it was that could go to the AAT, and which I think represented about 0.2% of overall Robodebts. So very few debts were really getting, I guess, proper internal review decisions. And again, this is something that it's sort of unclear to us what the path forward will be with Centrelink here. Many people were directed into a reassessment, which still required people to then challenge that decision to get an arrow. People were refused any sort of review without providing new information. And then, of course, the age-old problem of there being no time frame by which Centrelink has to conduct an authorised review officer review decision, so that people were waiting many, many months, even years, for a review decision because it somehow slipped off their system, and that the debts would come off hold and tax returns would be garnished. Meanwhile, the person thought they were waiting for an internal review. So I guess for us lawyers, it was really disappointing that those statutory rights were being thwarted. But for clients, it really contributed to that profound sense of unfairness and confusion and being caught in an impossible bureaucracy that I'm sure everyone saw either through their client experience or in the media. And I'll just hand back over to Miles.
And the other element of this is just that that one of the key frustrations, and I'm sure Terry can speak to this, is the fact that even when things were getting through to the Administrative Appeals Tribunal, and despite the obligations under Section 8 of the Social Security Administration Act to have regard to the decisions of the Administrative Appeals Tribunal, that Centrelink were not paying attention to those decisions, and in part there were not many publicly available decisions because they were being made at the first tier review of the Administrative Appeals Tribunal. But the fact of the matter is that there were 76 decisions that were made before Robodebt was, or at least 76 before Robodebt was cancelled, that did not support the approach that Centrelink were taking, and that and I guess there's two themes here. How do we ensure that that Centrelink does have regard to the decisions of the Administrative Appeals Tribunal generally? How do we ensure that it does that those decisions are publicly available? There doesn't seem to be a process to do so, but also perhaps on a note of optimism, perhaps this means that there is a greater capacity to put pressure on government to have regard to those decisions in future in other areas of our practice. So particularly in our DSP work, there are some very useful AAT decisions that we would like to see applied more by government. So I think in terms of where to next, some real consideration about how we can embed the important work of the AAT in government decision making should occur. I thought we'd just quickly reflect on our frustrations with the complaints process as well. Because we were not getting much luck with the reassessment process in terms of getting things moving, and particularly in once we had the decision or the concession by the Commonwealth in the federal court, we were still seeing Centrelink delaying and not making decisions that reflected the unlawfulness at the heart of Robodebt, and we initiated numerous complaints that we then forwarded on to the Ombudsman. And I guess our sense was that the Ombudsman was not interested in engaging with the lawfulness issue, and instead treated them quite technically in terms of what steps Centrelink had taken to address the complaint. I'm not sure, was that your experience as well, Charlie?
Sorry, just jumping off mute. Well, I guess only to say that those complaints are still ongoing, and they were obviously made at the beginning of the year, well before the refund announcement was made. So I guess we're yet to see the fruit of those complaints.
And then I might.
I think I just missed you there, Miles, but I'm assuming you're handing back over to me.
Yes, I am. There you go.
Yeah, no worries. And so this is probably something that, this may be something that many of you are already aware of, but we just wanted to really reiterate the power of client stories in telling the Robodebt story and communicating that with the public. And I guess also reflecting, I guess, in a positive way, that how much the media narrative changed over time. One of the things that, quite shocked us, I guess, looking back, we'd kind of forgotten that Robodebt began with a current affair, news stories, and media where Alan Tudge, the then minister, was quoted as saying things like, "We will find you, we'll track you down, and you will have to repay those debts, and you may end up in prison." And pictures of robots and talking about how great it is because now they could send 20,000 debts out the door, and how much that changed to a focus of on the social security system itself rather than fraudsters, and the importance of having humans making decisions. And one of the things that was a challenge for us in the client stories, and I assume not just for us but for media and other organisations, was that early threat of Centrelink releasing personal information, as what happened with Andy Fox. Although we kind of didn't see that again later, it was part of the framework. One of the things we wanted to, I guess, touch on was that the power of the client stories was really that for lawyers, we really see the legal aspects of Robodebt. But that's not what most of the media stories focused on. I think very few of them ever explained the averaging behind Robodebt. They really focused on the unfairness of it and the effect that it was having on people. And I think that those stories are what carried through, most often not the legal arguments. And I think it just really reiterates how powerful it is for clients to tell the stories themselves, and how that conveys through to the public then, I guess, our lawyerly ways of explaining issues like this. And then I think that's us done, Miles. So I'd hand back over to Carly.
Thank you so much, Charlie, Miles and Terry, for firstly giving a recap of what's happened since we last heard from Terry, and then what's happened over the past few months of this year. So there have been quite a few questions that have come through. So I know that we are getting close to 2 o'clock, but we'll try and deal with the questions that have been sent through. Just a reminder, if you do want to ask a question, please just type it into the chat box on your GoToWebinar control panel. So firstly, and it was remiss of me to say this at the beginning, but thank you to Economic Justice Australia, who have partnered in this session and have brought together these fantastic speakers. So Linda from EGA has actually just put a comment into the box as well in relation to cashless debit cards. So EGA have been advised that refunds are being made to ordinary bank accounts, and Centrelink is making efforts to contact people with CDCs and get their bank account details. So thanks, Linda, for that update. And I don't know if any of our speakers had anything that they wanted to add to that at all. Okay, so I'll just go on to the next couple of questions. And so one from Lisa asking whether it is easier to establish harm if the person is on a disability support pension when they received their Robodebt.
I can handle that one. It's unlikely that it's a Robodebt. That's the first issue. There are attributes that can be a bit like Robodebt, but no, the real issue is in establishing that the government owes a duty of care, and there are, you know, high court cases that say that you've got to look at a whole broad matrix of what the statutory purpose of the scheme is, what other remedies are available. You know, we've heard about there are lots of remedies, but they didn't work. Yeah, the long and the short is not that it's not possible to establish that there is a duty of care and that it's been breached and it's caused harm, but that it's a more difficult task than it might be if you were suing somebody else for their negligence.
Thank you, Terry. So the next question that I'll go to is, because given we're talking about telling stories and how important that is. So Jeanette has asked whether there are any support services or guidelines to help clients effectively tell their stories in the context of negative media portrayal. Perhaps Charlie or Miles, I could go to you on that one.
Yeah, sure. To be honest, I expect there is more publicly. I know that we have guidelines within legal aid, and we work, you know, our lawyers work with people within our communications team to support people and to, you know, advise them about the risks of engaging in media. And our experience was with Robodebt was that at that point the narrative had changed so much that nearly all the feedback and response was very positive, and so the clients, their response to us was that it was a very empowering experience and they actually got a lot out of it, but that was a concern for us. I'm not sure if Miles, if you know of any guidelines that we could point to publicly available.
No, but there's a great, I'm happy to track it down and send it around to the group if people haven't seen it, but there's a great paper that has been done on how we tell client stories, which I think has really informed the approach that legal aid has taken. So in the time I've been at legal aid, I think it's an area where we've really developed our capabilities, and I think a lot of it's informed by this paper. So I wish I could remember its name, but I'm happy to share it with the group if people haven't seen it. It's a really useful tool, I think, in how we put clients at the centre of our advocacy.
Thanks, Miles. Yes, I think I've actually seen that paper, and I'm pretty sure we actually had that presented to a webinar for us a couple of years back. So I'll liaise with you and we'll make sure we get that paper around to this group. Thank you very much for the reminder. So I'll go now to Amanda's question. So Amanda has a client who has 3 Robodebts who joined the Gordon legal class action but hasn't yet been repaid for any of those debts. If anyone could comment on the reasons behind that, that would be most appreciated.
I don't have, I don't know what, in terms of what the timelines are, apart from what I've looked at the publicly available information. I'm not aware of people who are involved in the class action being prevented from getting repayments, but perhaps others can comment on that. That's the only reason I can think of, unless the government's just not keeping up with its timelines, which is also, of course, possible. So, or she hasn't engaged in terms of providing her bank details.
Yes, I think it's likely to be the latter, as you've indicated. I'm not aware of any impediment at all that prevents the repayment. The other possibility is, unless it's been mischaracterised as a robodebt and there are some other quite extraneous issues that are the real foundation of the debt, but that's highly unlikely in the class action if she's a class action participant, because all of those were carefully screened. So yeah, no, I think you're right.
Okay.
I also wondered if it could be that initially a robodebts were raised, but they've since recalculated them, and if they've recalculated such that there's a correctly calculated debt now sitting there, they wouldn't refund money taken even in relation to an unlawful debt unless they had over collected. That's the only other aspect I could think of.
Mm-hmm.
Mm.
Thank you. And we've got some very helpful people in our group who are providing a potential reason why that might happen as well. So Bryn has mentioned that the government is refusing to talk to callers because they're involved in the class action, including regarding their bank details. So I'm not sure of whether that might be the reason, but certainly something to consider. Yeah. So I might now go, there's a lot of questions coming in, so I'm just trying to work my way through, and thank you for that one, Amanda. So in regards to the current debt pause, Linda's asked whether there's any indication that Centrelink has been recalculating debts for people with cancelled robo-debts, and that they'll be advised of these new debts once the debt pause is lifted.
I assume that we can't rule that out. So, for example, we are seeing examples of people being prosecuted for debts that were originally identified using ATO averaging. My understanding is those debts are then properly calculated using the usual process by which Centrelink does an investigation for the purposes of a prosecution. But it does make me think that that potentially, particularly where they've identified that there might be something that the subject of a social security prosecution, that they're likely to revisit and go through that normal process of investigating the debt and obtaining bank statements and that type of thing from the bank. And then but I haven't seen any examples personally, and I'm not aware of anywhere people have had a refund and then or been identified for a refund and then been subject to formal notices to their employers or to banks and that type of thing. But others might have seen that.
Okay, so I might go to the next question then from Catherine. So after STP is introduced and the single touch payroll, that is introduced, and debts start coming through using the new rules of assessing income, can we have another webinar on how to read Centrelink's calculation documents? I imagine the documents will look quite difficult. We'll keep that in mind, Catherine, thank you. And I know we've got Economic Justice Australia on the line as well, so possibly we can arrange another session in due course on that topic. This person has left, but it is an interesting question that I think hasn't been addressed, and it would be good to maybe hear your views on this, presenters. So Jennifer has and a content warning here for anyone. This is around really the mental health impacts of the robo-debt. So this person's son committed suicide after the robo-debt letter came to him, and the mum is now part of the class action. And is wondering what's the likelihood, I suppose, of Centrelink, addressing the mental health implications of this issue.
Well, there exactly. Of course, one most egregious, most important subset of the harms that are being alleged to flow from breach of Centrelink, the government's duty of care, if it can be established, There's also a significant issue about causation when it's a mental health issue, and then the assessment of a damage. But there are multiple steps in establishing a negligence liability, I suppose, and it's got as, if negligence can be established, the duty of care, then of course any mental health harms, whether it be the death of a person or the very large number of people who were enormously traumatized by the experience and continue to be when they came before tribunals and so on, it would be part and parcel of the playing out of that legal principle.
Charlie or Miles, did you want to add anything to that?
I don't have anything to add. I mean, I agree with what Terry said, so.
Okay, thank you so much. So the next question is from Bryn, and they're asking, to what degree does the concept of practical onus apply to other types of debts, for example, carer payment or CCB payments? And Bryn has their hand up, so I'm not sure if you wanted to be unmuted. Oh, nope, hand's gone down. I might just hand over the question to our presenters then. Thank you.
So the idea of practical onus, I guess, really influenced our thinking when we were looking at the new single touch payroll, because I guess what defines Robodebt, and I guess this is what's behind your question, Bryn, is that capability of the government to say, well, we can come to a conclusion that might be wrong unless you can prove otherwise. And, you know, my concern is that with single touch payroll, that there will be this capacity to determine that a particular payment doesn't relate to a particular period unless the client proves otherwise. And so I can see why this question might arise in other areas, but I'd be keen to hear from Bryn about exactly how it might arise for those two types of payments. Is it a particular mechanism that you're concerned about?
Okay, I'll just...
Unless others have something to add, yeah.
Sure, I'll just unmute Bryn and see if they're able to speak to that. Oh. No. Oh, there we go. Should be unmuted.
Hi, yes. Hi. Thanks for that. Can you hear me?
Yes.
Yeah.
Great. Thanks for taking the question. So this is really about where you've got debts that are raised on the basis of qualification and they cover a number of years, for example. So if I take carer payment for an example, where a person has had a one-off conversation with a Centrelink employee, and on the basis of that conversation, they've then had a debt raised for the last 8 years based on them not qualifying. It's then when they appeal that, it becomes apparent that Centrelink, have very little detail or information about the actual qualification for that payment or the issue of qualification. So for a carer payment, they don't actually know if that person was providing care for the last 8 years. It's just this most recent thing. So this recent statement that they're trying to extrapolate from. But when that goes to the AAT, really the only person there to give evidence is the payment recipient. And practically speaking, the onus is on them to actually prove that they did qualify for that entire time period, which seems to contradict that concept of practical onus being on Centrelink. And so I'm just wondering if that is something that you've explored. It's something that I've run up against a few times, and I've definitely thrown out Terry's article, but it's fallen on deaf ears at the AAT. So I'm just wondering if that's a concept that you can talk further to, and whether that is actually something you guys are seeing or exploring in your casework.
I'd be happy to chat in more detail by email subsequently, but the practical onus applies to any and all debts, that there must be sufficient information that is relevant to there being a debt or not. Qualification, that's a matter for, you were talking about AAT, that's a matter for the tribunal to use its powers to satisfy itself, irrespective of what the person is saying or Centrelink has said about the existence or non-existence of eligibility. And if there are AAT members who are, you know, falling down in the job in failing to proactively ensure that either from the applicant or from other sources, by exercising the sorts of powers that we've been describing in relation to establishing debts, you know, the power to compel employer records or bank accounts to be provided, and that applies more generally to anything else that might be pertinent to eligibility. If that's not being done, then you know, it's a sad reflection on the quality of the work that AAT member is doing. It's, as I say, the obligation of the decision maker, whether it be Centrelink or the tribunal, to get to the bottom of eligibility, you know, is clear. Clear as a matter of law. I mean, it's yeah.
And if just if there's insufficient information, because my understanding is the default position is if there is insufficient information, then a debt should not exist. But it appears to me that in practice, that's not the position that's taken either by the AAT or by Centrelink.
Well, it's Professor Robin Creek who gave the characterisation, the label, a practical onus, in order to differentiate it from the civil onus of proof and the criminal standard of proof beyond reasonable doubt. Because strictly speaking, as McDonald establishes for the lawyers who like these things, there is no onus of proof in either the civil or the criminal sense that relates to those other bodies of law. It's a different kind of animal, if I can put it that way. But nevertheless, there is a responsibility to provide a sufficient basis for coming to a conclusion one way or the other. All decision makers, but the AAT in particular, can't really opt out and say, oh, look, I don't have sufficient information to be satisfied one way or the other. If they reach that position and there's no other way of obtaining the information, you've still got to make a decision. What I was saying was that usually there would be ways of getting the required information to enable you to be, you know, very confident about the decision you were making about whether there was a debt or not a debt. It's complicated, sorry.
Brendan, Terry, perhaps I can connect you to continue the conversation offline. I might now go to, there are a few more questions, but I'll just take one further question and we'll wrap up for the day, given it's almost 3:15, New South Wales and Victoria time. So this one's from Kylie, who's just asked, what about the issue of Robodebt raised debts being prosecuted in whole or in part? Kylie has cited evidence in one case that went to sentencing hearing 2 days before the customer received the class action opt-out notice, and the prosecution component was under $13,000 in 2 sub-periods of a $27,000 Robodebt.
In Victoria, most social security prosecutions are dealt with by our Economic and Social Rights program, because we are concerned to make sure that anyone providing advice to a client who is considering entering a plea needs to be wary of the way in which the debts would be calculated. I mean, I'd find it very difficult to imagine, but perhaps it's just a failure of my imagination, that the Commonwealth would be prosecuting debts as fraud on the basis of ATO averaging. So I'd want to have a close look at the prosecution file, but at the same time, I couldn't believe when I saw what was happening in Robodebt either. So anything's possible, but I think it's really imperative that anyone working with social security fraud, people accused of social security fraud, really needs to make sure that they're doing a proper analysis of the file for exactly the reasons you've identified. I'm not sure if that answers your question, because
Yes, and not only a proper analysis of the file, but proceed to AAT review if required in order to establish the true quantum of the debt, which is often very significantly less than the one that was originally raised and serving as the basis of the criminal prosecution. There was an issue debated 20 years ago or so about whether that prejudiced a client and their right to silence and all the rest, but the protocol at the AAT for 20 years or more has been that while you know, one may be careful when you're advising a client about what they may say about their intent and so on in the hearing, it is nevertheless almost always extremely advantageous for the client to get the true quantum of the debt quantified before the criminal prosecution goes to trial.
All right, thank you so much. We might wrap it up there. Thank you so much, everyone, for hanging on the line and sticking around to hear those questions, and apologies to those people whose questions we weren't able to get to today. But on behalf of everyone who's listening, thank you so much to Terry, Miles and Charlie for coming in and presenting on this topic today. I'm sure that there is more yet to unfold, and together with Economic Justice Australia, we'll keep you posted of any further webinars in this area that we might be able to host. But thank you all so much. I have located the Consumer Action Law Centre paper, which is People Who Help People, and that is around telling client stories. So I popped that into the chat box, but I'll also flick the link out to you all with the recording to today's webinar later this afternoon or tomorrow, so you can have a look through that. So thank you all again, and we'll see you next time.
Thank you.
Great, thank you.
Thank you.